Good evening. This is Rahul Reddy, live here from Houston, Texas, from REDDY NEUMANN PC. We are here for immigration news every week, every Tuesday at 5 p.m. Central Time. Along with me is my business partner, Emily Neumann. Emily, what do you have today?
All right, this week we're going to be talking more about the H-4 EAD debacle that is the current situation with the Trump administration and the very long processing times we're seeing ever since the biometrics notice requirement came out. We're going to talk about what we're seeing in some I-140 petitions, requests for evidence, intent to revoke, where there's inconsistent information in the PERM application and experience letters versus the DS-160 visa application that's submitted at the consulate. So we'll talk about that. And we're going to also talk about continuing issues that we're seeing for students who are using day one CPT and what's coming in those students' H-1B petitions that were filed this year in the lottery. And we'll also talk a little bit about changing employers when you have an approved I-140. When is it safe to do that? When should you wait? How is your I-140 going to remain valid, and what you can use it for after you've changed employers? And of course, we'll answer your questions.
You can pose your questions on either YouTube or Facebook. We are going to try to cover as much as possible. And if you can't get through, you can always make an appointment with me, Emily, or any of our good lawyers that we are that are working with us. Emily, the H-4 EAD is becoming a big chaos. I mean, it's just like, what's going on in the H-4 EAD? Previously, we used to get the H-4 EAD approval along with the H-1B. Since the fingerprinting has started, that hasn't been coming right now. Can you explain why there is a change recently on the H-4 EAD as compared previously, and why is that? What other options they have if the H-4 EAD is not given option?
Yeah,
if they're not given.
I mean, up until March of this year, we usually were able to file an H-1B extension, an H-4 renewal, and an H-4 EAD all together with premium processing. And when the H-1B got approved, the H-4 and the EAD got approved at the same time. All of a sudden in March, we started seeing a delay in the H-4 approval and the EAD approval after the H-1 was approved. And initially this was, we knew it was coming because USCIS had come out and said they're starting this new biometrics requirement only for the I-539, so that's just for the H-4 holder. And they said that because of the processing time it takes for the biometrics to be done, it's not possible to get the fingerprinting done and get the H-4 approved within the 15-day premium processing. But they also said that they would process the H-4 on a priority basis after the biometrics were done if it was filed along with a premium processed H-1B. That just never happened. So they're basically just separating the H-4 and EAD from the H-1B, and if it was filed together in premium processing, they don't care. You can't even contact the premium processing unit about it to find out the cause of the delay or when it might be approved. So you're just stuck with regular processing time, which the whole reason most people file in premium is to get the spouse EAD faster. So we tried service requests, we've tried the congressional inquiries, we've tried the ombudsman office, nothing works. We've tried expedite requests, nothing works. So the best thing we've found is to file a lawsuit on behalf of groups of H-4 applicants that are waiting for at least 30 days after they filed the H-4 and the EAD, and we're seeking to ask the court to force USCIS to make a decision on those applications because it's no longer a reasonable period of time for them to wait.
Emily, on the issue of the day one CPT, you said there's still problems in the day one CPTs trying to apply for the H-1B. What are you noticing in the day one CPTs?
Yeah, I think that some people, kind of got a false sense of security after the unlawful presence memo was put on hold. And so even in the H-1Bs that were filed in this CAP season in April, if you requested a change of status from F1 to H1 and you've been using one of these so-called day one CPT schools, a lot of people are getting a request for evidence on the maintenance of status of F1. The USCIS is questioning whether that CPT was properly authorized, how you're getting CPT from day one because you're supposed to go to school for 2 semesters before you're eligible. How is it that you're getting it for a second master's degree because they feel that you should go up a degree level after you've used your 3 years of OPT to get more practical training time. And people are not successful in responding to those. You very likely will get the change of status denied. So in our cases where we come across that, we recommend converting the application to consular processing and avoiding a determination that you violated your F1 status.
Emily, on the inconsistencies that you have noticing, you said that you're going to discuss more on the inconsistencies. What are the inconsistencies have you seen when people are applying the visas in their home country, and then when they're coming into and they're applying the H-1Bs, they're applying the green card applications, either to family-based or employment-based? What is the common inconsistencies that you're seeing, and what are the difficulties that are, and what is the solution for it for the intending people who are coming into the United States? What should they be careful? What are the pitfalls in there?
Yeah, I think the most common issues we're seeing is different dates of employment and different job duties. So different that it sounds like it's a different job. And this is happening, with the DS-160 and you're filling out your employment history, you might be putting just kind of your basic occupation and your general employment dates and listing very general job duties. And then in your labor certification, you're going to be much more specific. You have to put exact dates because you're counting that experience to meet the requirement for the position. Maybe there are certain skills that you have to demonstrate you have experience in, so those skills are going to be listed in that experience section. But if those 2 job descriptions and the dates are so different that it seems like a big inconsistency, you could end up with a notice of intent to deny on the I-140 or even a notice of intent to revoke after it's already been approved if they're seeing further inconsistencies between the DS-160 and the PERM form or experience letters, and even between the H-1B petition. And when you're filing an H-1B, there's a specific job title, there's specific duties that are mentioned in that petition, and it should match with what you're actually doing, and that should match what's on the PERM form.
Okay, Emily, coming to the last topic that we have is, 1 second.
I-140
Right.
validity.
Now, we all know that the I-140 validity is there. If the I-140 has been approved for more than 6 months, 180 days, if they leave the employment, they can keep the I-140 priority date. They can use it for the H-4 EAD. They can use it to port the date. They can use it to extend the H-1B. There are some rumors that, hey, the employer cannot withdraw the I-140. The employer cannot, if the employer withdraws the I-140, there might be some negative effects on those things.
So an employer can still withdraw an I-140 even after 180 days. The difference is what is the effect of that withdrawal. So if the withdrawal happens after the I-140 has been approved for at least 180 days, the withdrawal will not cause the I-140 to be revoked. The I-140 remains valid for you to continue to get extensions beyond the 6-year limit, and for you to keep that priority date, and for your spouse to get the H-4 EAD even though the employer withdrew.
Coming back, let's go to the questions, Emily. There are some questions coming out from the YouTube on the H-4 EAD. I've filed a H-4 EAD along with the H-1B. I got the H-1B approved, but H-4 and EAD are still pending. This question is coming from Sandeep from YouTube. What solutions does he have to get his wife's H-4 EAD?
Yeah, we haven't found any other than litigation. So if the H-4 has been pending for at least 30 days at this point, according to Congress, that's an unreasonable period of time for you to have to wait to get a non-immigrant visa application approved. So you can file a lawsuit in federal court asking the court to compel the Immigration Service to make a decision on that case, because they have to make a decision within a reasonable period of time according to the Administrative Procedures Act. So once we file that lawsuit, the government has 60 days to respond to the lawsuit, but typically rather than responding to the lawsuit, they just adjudicate or approve, make a decision on the H-4, which then allows them to make the decision on the EAD. We get both approvals in the mail, and then we can withdraw the lawsuit.
I know you say that litigation is like a small thing kind of thing, isn't it? Doesn't it cost more money to litigate? And there are a lot of rumors that once you file a case against immigration, the government of United States, they're going to come and get you. Mm-hmm. Is there any?
Yeah, a lot of people are worried that that's going to impact them. What about their next H-1 extension? Maybe they're going to just find some random reason to deny it because we filed a lawsuit, or maybe their green card will get denied because of it. And that's not possible. I mean, the government has to have a lawful, valid reason for any denial decision. It has, and they don't retaliate against individuals because you're using your right to seek assistance from the court. They're not going to hold that against you. And as far as the cost, yes, litigation can be expensive. We've found a way to group together multiple applicants in one lawsuit, which greatly reduces the cost because everyone shares the cost together. So it's not as expensive as you might think, maybe a little bit more than the cost of premium processing. And it's definitely, you're thinking about, I'm losing out on 2 or 3 months worth of salary versus, spending money on this lawsuit that might be giving me the opportunity to not lose out on those 2 to 3 months worth of salary. I think that it's well worth it, and it seems to be working.
I'll go to the questions from the YouTube. Prashant is having this question from YouTube. He has a green card. How long does he need to stay with the employer? Is there a set minimum time rule where he has to stick with the company once he gets an employment-based green card? Prashant, no, there's no set rule on it. If you leave immediately after you get the green card, we have not seen any problem whatsoever at all. Now, since the AC-21 law came in about 8-9 years ago, now they made it more official, where if you leave it, it's not going to impact at all after you get the green card. Another question that came from YouTube, Neeraj is asking the question, can you expedite the F1 to H-1B? The best way to expedite that I can tell you is by going to premium processing. There are other methods of doing expedite, but I think so the cheapest and best method is to go to premium processing. There are some times where they stop the premium processing, but right now the premium processing is there.
Pradeep from Facebook wants to know if you can change employers while your H-1B extension is pending with your current employer. And it sounds like this current petition has already expired, so you're working on the 240 days that allows you to work beyond your I-94 expiration. So the short answer is yes, you can, but your extension that's pending becomes what's called a bridge petition. It's the bridge from the end of your I-94 to the filing date of your transfer. And if that bridge collapses, when you get your transfer adjudicated, you're very likely not going to get the extension of stay approved. Your transfer is going to be approved without an I-94. You have to leave the country, get the visa stamped, and then come back in to get back into H-1 status and continue working. So yes, you can do it. Be aware of that risk. It may be better to get the extension approved first and then transfer, unless you're worried that the extension might be denied. Then I think the transfer might be a better option.
Question from Pradhan from YouTube is that his OPT is expiring in 2021. He's going to file a H-1B in 2020. He is working from home. Will it cause any problem in the H-1B application? I would try to work from the company location. The reason is that there's a little bit questionable mark here, is that when you got an OPT or STEM extension, the employer must have reasonable expectation that he's supervising you. When you're working from home, that supervision is gone a little bit, and it may lead to some questions by the USCIS. I will try to see if I can work from the office location. If not, I think so you should have enough documentation how the employer is able to supervise when you're working from your home. If they have enough documentation nowadays, I mean, I've seen robots that have been handled in the Mars. When I say Mars, I mean it's a different planet, guys. They're from Houston. They operate from Houston, actually, from the city where I am located at. We have also seen that drones are going and bombing people, and they're controlling those drones from Longview, Virginia. I mean, that can be done. I mean, people can be controlled, people can be managed, but enough documentation is needed to support if the USCIS is going to ask any questions on the H-1B.
Hemant from Facebook has a question about specialty occupation requests for evidence. This is the most common type of request for evidence. This is where the government is asking, does this job normally require at least a bachelor's degree in a specific field of study? There are 4 ways to prove to the government that the job is a specialty occupation. You only have to prove at least one of them. I do have a blog post, a couple of them about that. So if you go to immigrationgirl.com, in the search, you should be able to type in specialty occupation and probably find some. But some of the documentation that's normally submitted is industry articles that talk about what education is required for that type of job, job vacancy announcements from the company that's sponsoring you, showing that that company normally requires the specific bachelor's degree to do that job. Job vacancy announcements from other companies that say the same thing. Expert opinion letters can be useful, or letters from competitor companies that are in the same industry that hire for that same type of job. And also any information about what's so special or complex or unique about the specific job that you've been sponsored for that causes the need for that bachelor's degree.
Emily, I need your attention on this YouTube question from Neeraj. His perm is approved. His previous employer is not putting the skill set that he worked on in the employer letter. Is there any way to get around to get the I-140 approved? I know you have written an article on Immigration Girl on that.
Yeah. So sometimes when you're filing the I-140 petition, if not all the skills are mentioned in the experience letter, the Immigration Service might still approve it without further documentation. Sometimes they might send a request for evidence for more documentation of those specific skills, especially if it's listed as a special skill on the perm form. So in that situation, affidavits from former coworkers can be a good way to do that, as long as it's supported by W-2s or some pay stubs to show that you did work for that company at that time. That's usually going to be the best way, is through those affidavits. And I do have on immigrationgirl.com about proving I-140 experience when your employer is not willing to provide that letter.
I need your attention on this one, Emily. Neeraj again from YouTube, but this is a different Neeraj from YouTube. He's asking a question: is consular processing a safe process for the people who are on day 1 CPT that are applying for H-1B?
Well, yes, generally. And that's partly because the unlawful presence memo is currently on hold. So as long as you have not exceeded unlawful presence of 180 days, you're still eligible to apply for a visa and have that approved. There's nothing that makes you inadmissible. That's what the consulate is looking for when you go for visa stamping, is do you qualify for the visa that you're applying for, which in this case is the H-1B. There's nothing regarding CPT that's needed to prove you qualify for an H-1B. And then they look at, is there anything that makes you inadmissible? That would be more than 180 days of unlawful presence, more than 180 days of being out of status, medical grounds of inadmissibility, criminal grounds of inadmissibility. So generally, as long as you're not exceeding that and you haven't committed any kind of fraud or misrepresentation, you fill out your DS-160 properly, we haven't had people that were running into problems with getting that approved, as long as they're accurately filling everything out.
Good Karma and Dheeraj has this question, and Sunanda has a question from YouTube on the cost of the H-4 EAD litigation. I would recommend that you send an email to info@rnlawgroup.com. We don't give the real cost out on the YouTube or anything like that, because it keeps changing depending on the amount of work. Another question comes in from Dheeraj from YouTube. Is asking question: are there any H-4 EADs that got approved that we filed the litigation on July 19th? The answer to that question is yes, we have. But I have to elaborate, not all cases got approved. Only some cases got approved that we filed in July 19th. As Emily was pointing out before, when we file the litigation, we file between 20 to 40 cases we file grouped together to reduce the cost and pass it on to our customers. Otherwise, it's going to be expensive to file each individual personal litigation.
Manny from Facebook wants to know about what the normal processing time is for the H-4 and the EAD when it's filed along with the premium process and the H-1B is already approved. I think we still have many cases that were filed back in April that are still pending. So processing time is at least 4 months, if not longer. You really have to look at the I-539 processing time listed on the
I'm not sure I would
website.
trust the USCIS website, particularly with the Nebraska Service Center, Emily, and also Vermont Service Center is backlogged very significantly than what they are saying. And when you do contact them, they'll just say, okay, you raise a service request, we're going to answer in 60 days, which they may or may not. If not, raise another service request. It is taking a long time, but sometimes, not all the times, but sometimes they are right on the website that some of the cases that they are filing is right.
Aparna from Facebook wants to know, is it okay to have an H-1B extension and an I-140 petition filed at the same time? As long as the H-1B extension is not dependent on the I-140 expiration, meaning that your H-1B is not requesting time beyond the 6-year limit, it's totally fine to have them both filed and pending at the same time. You don't have to have the I-140 approved first, as long as you're not relying on it to qualify for the extension.
Can I apply a counsel, Jilgam has this question, can I apply a counsel processing and premium processing for a day 1 CPT RFE? Yes, you can. If you have not already filed the counsel processing, you can convert into a premium processing, and you can convert into counsel processing.
Ganesh from Facebook wants to know, what are the odds of getting stopped at the port of entry if your H-1B visa only has 6 months validity left on it? I don't think I've seen anybody have an issue with that. I usually do recommend that you carry an employment verification letter from your company, and in that letter it might be helpful if the company mentions that they're planning on filing your extension once you return back into the US, but I don't think we've had issues with that.
Question from YouTube. Can a 485 green card application that has been filed for the adjustment of status through employment based, can it be approved before the I-131 and the I-765, which is an advanced parole and employment authorization? Yes, it is possible. It used to happen very frequently until March of 2017, but since March of 2017, I haven't seen any approval of the 485 before the 765 and the advanced parole. The reason is that now they are wanting every adjustment of status to be interviewed, and that's taking a long time to get approved. So I have seen it previously, but I haven't seen it recently.
Question on Facebook is, are we only talking about H1, L1, the employment-based type immigration, or can we ask questions about family-based immigration or visitor visas and that sort of thing as well? Probably for that I would recommend our daily conference call where you can get answers to some of your other immigration type questions. If you go to rnlawgroup.com, you'll find the phone number and the schedule for that, and you'll be able to join in and get those questions answered.
The question is that can a H from YouTube is Shamsundar has this question. The H-4 extension is pending. Does the 240 day rule apply for H-4 too? No, the 240 day does not apply for the H-4 extension. They can continue staying until the H-4 is adjudicated. And since nowadays having a H-4 extension pending for 240 days is just normal. So you can continue staying in the United States until the H-4 is adjudicated. Absolutely no problem with it. Questions from YouTube. Vic has this question. I-140 has been approved. The priority date is December 2019. Would H-1B be renewed typically without issues? Vic, the issue would be that it has nothing to do with your I-140 approval. Just because you got a lot of extensions before doesn't mean that your extension is automatically going to be extended. We have noticed a significant H-1B extension that we're routinely getting approved before or getting into question. I would recommend that you apply for the H-1 extension way before your I-94 expires. And so that if by any chance your H-1B gets denied before your I-94 expires, there'll be a lot of different options that you'll be having.
Pankaj wants to know if you can return back to the U.S. from Mexico under automatic revalidation if you've already submitted your fingerprinting for the visa renewal. So that sounds like you're saying that you've actually submitted the DS-160 to apply for the visa stamp in Mexico. Once you've applied for the visa stamp, you're no longer eligible for automatic revalidation. You can only use that if you're traveling to Canada or Mexico for less than 30 days and you're not applying for the visa stamp, then you can return back using the same I-94.
Ram has this question from YouTube. Is there any reason why consulting companies want to wait until the deadline before responding to the RFEs? What's the reason why? A lot of times, Ram, you may be right. There are some pluses and minuses of responding to the RFEs before the deadline. I mean, one thing is that the lawyers will keep on mushing and pushing. So when it comes to an RFE for our law firm and our lawyers are requesting documents from the employer, we would like to get all documents. We want the end client letter. We want the end client letter exactly the same way. We want the statement of work. We want the contract between the end client and vendor letter, end client and vendor. And if there are two vendors, we want to have a contract between them. We need to have SOWs. So what happens when the employer does not provide? The lawyer keeps on kicking back. I need this, otherwise your percentage of denial will be higher. And the employer and the employees at that point of time will try to debate. And sometimes it extends to the last, it goes, almost near to the deadline. Lawyers don't want it. I don't think so. Employers want the tension. I don't want employees want the tension too. It's just because the documents are not obtained in a proper timing. That's the reason why most of these cases get extended for a long period of time. Do you think so? Any other?
Yeah, I think a lot of times that is the situation. I think some other times, if the case is a weak case, the employer might want to try to get as much time as possible with the person eligible to work and will delay responding to the RFE as long as possible to buy more time. So, but mostly, yeah, it's just a matter of getting all of the documents together. It takes a lot of time, and drafting it is a very time-consuming process to respond to an RFE. Ganesh wants to know if the same type of litigation can be used for delayed H-1B approvals, and the answer is yes. Instead of filing or upgrading to premium processing, you can file the exact same type of lawsuit asking the court to compel USCIS to adjudicate the H-1B because it's not being done within a reasonable period of time.
I have a question here, Emily. Why would I have to come to you when I can get that thing done for $1,400 with USCIS? I get the expedited thing. Are you telling you're going to charge less money than $1,400? And I have a guaranteed thing in 14 days.
Well, there are some benefits to the litigation, and that is that the Immigration Service might be a little hesitant to issue a request for evidence, or they might treat the case a little bit differently because now they know that it could lead to litigation.
It already led to litigation.
Yeah, exactly. So I think that there are certainly, yes, you're right, it does guarantee something within the 15 days with the premium processing. The cost is about the same. But I think especially for an employer, if they are going to show USCIS that they're not going to just roll over and pay $1,400 over and over again to get reasonable service, they might actually take the employer more seriously in future filings as well.
So in other words, there will be a fear for the USCIS, hey, don't touch this employer and employee, you're already in litigation. That might be the great advantage instead of going through premium processing, though cost might not be that much manufacturing. One question that comes from Dedipya from YouTube is that, hey, is it good to convert from H4 to F1? F1, what are the options? You may have to discuss with a lawyer though. Here is a problem. Previously, H4 to F1 used to get approval in 2 to 3 months. And now it's taking approximately, if it's a Vermont Service Center or a Nebraska Service Center sometimes, it's taking about 16 to 18 months. And you have to keep your H4 validity until that period of time. And sometimes what happened, by the time you get your F1 approval, you might have already completed the college if you're already going to the college. And you have to defer the admission every time. If your H4 EAD, H4 is expiring, you may have to renew it. So there are a lot of difficulties in practically getting the F1 approval. And you can't just go to outside the country, get a passport stamp the F1. We have noticed that people who are here on H4 who are trying to go to get F1 stamping, they're getting a lot of denials. You may want to be careful when you want to move to F1. I personally, coming on H4, and when I was in H4 for a period of time. My wife was in H1 and I'm period. So I don't see. I would rather try to move to EAD rather actually going to the F1, going through the whole hurdles that have been created recently by this administration.
George has a question. How long does a U.S. company have to be in existence before it can qualify to sponsor someone for an L1? There's actually a special provision for a startup company in the U.S. to obtain an L1 visa. So if it's an existing company outside the U.S. and they're going to establish a new company in the United States, as soon as that company is established and you have the lease agreement and all of the corporate documentation taken care of, that U.S. company can sponsor a worker to come to the U.S. Now, be aware that new office L1s are only approved for 1 year, the initial time, and then you have to prove at the end of that 1 year that the qualifying relationship still exists and that the company has grown enough to support likely a managerial or executive position. Usually startup are L1A manager or executive position. So yes, it can be done, but it's only given for 1 year, and that extension, that first extension, is kind of difficult to get if the company is not grown sufficiently during that year.
Question comes in is that my wife's H4 is valid for 2 more years. I'm moving to a different company. Is it worth applying for the H-1B extension at this point of time? Technically, you don't have to apply for the H-4 extension at this point of time, even though you are changing the company. However, please make a note that you need to apply for the H-4 extension before her I-94 expires. So if you miss that, that's going to be a problem. That's one point. The second point is that if your spouse is on H-4 EAD, you may want to apply it right now and get the 3 years extension if possible. I know it's an extra expenditure, but I don't know about the H-4 EAD. That's one thing, how long it's going to be there. The second aspect is that we have noticed that H-4 plus EAD, unlike before, is taking a long period of time, and you may avoid it if you file along with your H-1B at this point of time. Rather than going for a litigation process, I would rather want to get it done right now. This is only if you have the EAD and your spouse is working, you may want to file for H-4 plus EAD along with the H-1B.
Question about going for stamping. So this is someone who got the H-1B approved recently and is going for stamping for the first time. What kind of things do I need to keep in mind? So number one, when you're filling out the DS-160 visa application form, make sure you're filling it out accurately. Remember, now you have to list all of your social media handles there. That's a new question that popped up a few months ago. But most importantly, what we find is people don't read the petition that was filed on their behalf. So when they're answering questions about what the job is that they were sponsored for, they have no idea what the employer said at the petition, and they might say something completely different, or at least it sounds different to the officer, but maybe they're not as familiar. So you really need to read through the whole petition, the I-129 form, the letter of support, the LCA. Make sure you know what was said about the job, about the company, where the company is located, all the details about the job. That's going to be the most important thing. And then if you are dealing with a third-party placement situation where you're working at a client site, you need to understand who your actual employer is and that you are maintaining the employer-employee relationship with the company that sponsored you, not with the end client. You're not an employee of the end client when you're in that situation, so you need to make sure that you're able to articulate that in the interview when questions are asked about who's your supervisor, who's your employer, and who gives you instructions and that sort of thing.
To add those things, I want to check his LinkedIn, I want to check his Facebook, what is his employer is listed as. I want to be very careful on these things. Even previously also, they were checking these things around. It has become a mandatory what their Facebook is telling who the employer is. And if they are, let's say for example, if their end client is Pepsi and their company is ABC Consulting Company and they put employer as Pepsi, that may be an indication that you don't have good employer-employee relationship. Be careful with your social media, guys. You're watching us on social media. I mean, the whole world has moved into social media. It's open and everybody is watching it. So don't think so that if you have a different employer there, the USCIS, the CBP, and the Department of State is watching.
Manali from Facebook has a question about what happens if my H-4 EAD application is pending and we get a final rule that eliminates the H-4 EAD. As most of you know, there's a regulation in process that still has not been proposed yet, but the plan is to eliminate the H-4 EAD. Of course, we can't say for sure because we don't even have a proposed rule yet, but generally, when a final regulation is published, it will have an effective start date in the future, 60 days from the time the final regulation is published. So they will continue to process applications that are received before that effective date. That's our guess. That's usually how they operate in that kind of situation.
Karthik has this question from YouTube. What if a H-1B in-house has been revoked not for fraud of a willful representation? Will it impact the beneficiary visa number? And if he has moved on to a different company, it's going to be a problem. Well, revocation can happen. I mean, when you see online though, Karthik, the revocation can happen when it says that it's been revoked because when the employer withdraws the application. If that is the case, where the employer withdraws the application and it's been revoked, you have no problem. Absolutely, you're good. But if you're telling that it's been revoked, other than employer withdrawing it, no matter what you say, whether you say that it's not been withdrawn for fraud or willful misrepresentation, I see there is something wrong, Emily. I see there is something wrong. Because if the employer has not withdrawn, it's been revoked, I am concerned. I would want you to consult a lawyer because that looks to be a major issue.
Super Pratim from Facebook wants to know if they can use a previous company's approved I-140 to renew the H-4 EAD. And the answer is yes, as long as that I-140 was approved for at least 180 days. Even if the employee has left the company, you can still use that approved I-140 to renew the H-4 EAD, to continue getting H-1B extensions beyond the 6-year limit, and to keep that priority date, even if the company withdraws the I-140.
One question is that, Shruti asked this question from YouTube, can F2 travel to India while suppose he's on STEM OPT and H-1B got RFE in pending? No, I would not recommend to travel at all because when you're coming back, you will have a difficult time in coming back. I would not recommend that you travel. If you do travel though, wait for the H-1B to be approved and apply for the H-4 visa there in India or whichever country you're from, and then come back. But don't travel and come back into this country.
Nikhil wants to know if the I-140 has not been revoked for more than 180 days and the employee loses the job after that, how many days can the employee stay in the United States legally? So I think it depends on a couple of things. Number one, what's your current status? Are you working for this company in H-1B status? If that's the case, then from the date of termination, you have a 60-day grace period in order to find a new employer and file a transfer anytime during those 60 days. If you're no longer in H-1 status because your 485 is pending, then it becomes a different situation where you need to find the new position that's in the same or similar job category so you can submit the 485 Supplement J in order to continue that 485 processing.
Mehul has a simple question from YouTube. His I-140 is approved since 7 years. Can his spouse be eligible for H-4 EAD? Yes, absolutely. If the I-140 has been approved and not been revoked, you don't have any problem whatsoever at all in filing for the H-4 EAD. Lithika has this question, Emily, is that H-4 EAD is expiring next year, September. What is the right time to apply for the extension?
Well, that's a really good question.
Really good questions. The problem is that I'm assuming that your husband can only apply for the H-1 extension 6 months before, and unless his H-1B is approved, you can't apply for the H-4 extension or applied. So I would recommend that you have to apply in the 6 months period of time when your husband is getting the H-1B extension. Now, having said that, now they are not adjudicating the H-4s and EADs within 6 months, and that's a problem, Emily. Is that right? I mean, you can't apply before more than 6 months under the conditions because you have to wait for your husband's H-1B application to be filed. So you are limited with the 180-day rule. You may want to litigate if the things continue, but I'm expecting that with the way we are filing the litigation on the H-4 EAD and the USCIS has approved the cases, they might as well approve all the H-4 EADs in proper timing rather than all the clients come to us. We're expecting to file thousands of these H-4 EAD litigations if the USCIS continues to delay. If they correct themselves and they approve, that's good for you, good for us, good for everybody. If not, you may want to file the H-4 EAD and EAD extension and then come to us for litigating the matter.
Question from Rama on Facebook. I have H-4 that is pending since April, and spouse's H-1B is expiring in September. Spouse's employer already filed that renewal, but not the H-4 renewal. So the H-4 that's pending is very likely only going to be approved till September 5th when your spouse's H-1B status expires. So yes, you very likely will need to file another H-4 extension using the H-1B receipt notice and your H-4 receipt notice to prove you're maintaining your status while you're waiting on that approval.
How long does it take for the H-1B extension or amendment? Well, if you go in the normal process, it takes 6 to 8 months. Of course, you do have a premium processing. We may not be advising people for the premium processing if the amendment, but however, if the I-94 is expiring, I would rather want to get the H-1B extension decision way before your I-94 expires, because if your extension gets denied, you have multiple different options. But if you don't, if you get the decision before the I-94 expires, you have a lot of options. If you get the denial after the I-94, your options will be very limited.
Nasir G from Facebook, hopefully I said that correctly, wants to know if an I-140 has been approved and the 485 has been pending for more than 6 months, can the employee change jobs in a similar field but a higher level role, like a promotion? Generally, yes. So the rule requires that the new position be in the same or similar occupation compared to the one you were sponsored for. So as long as the occupation code, the SOC code, is similar, I think that going up to a slightly higher role is normal in your career progression, and we've not seen any 485J supplements denied or rejected for something like that.
Question comes from YouTube. Can I file a H-1B transfer while the H-1B extension is in progress? If the I-94 has not expired, you have no trouble whatsoever at all filing for the transfer. If your I-94 is expired though, you may want to wait until the extension is approved. If not, if you file it and you move to a new company, the officer will request that the extension be approved before your transfer can be adjudicated.
Prashant from Facebook wants to know, when you're using an old employer's approved I-140 and you move to the new employer, how long can you keep using that I-140 to extend the H-1B before the new employer has to file the perm? And the answer is you can continue using that old I-140 again and again to get H-1 extensions until your priority date is current. Once your priority date is current, then you need the new perm in place so that you can file the new I-140 and 485 based on the new company's perm.
Amit has this question from YouTube. I-140 is approved. Can I apply for the 485 by myself? No, you can't file the 485 based on the I-140 by yourself. You have to have your employer file 485. I mean, you can file it, but your employer has to sign the 485J supplement to file. So he has to cooperate. You must be having the cooperation of the employer to file the 485.
Siddharth from Facebook wants to know, once the H-1B has been selected in the lottery and is a consular processing petition, how long might it take to get the decision on it, whether it's an approval, a request for evidence, or a denial? If you don't upgrade to premium processing, it could be well into next year. We had many cases in January of this year, February of this year, March of this year that were still pending from last year's cap season, and I don't expect this year to be any better. So if you are, still pending in September without a request for evidence, you may want to ask your employer to upgrade that to premium processing. Otherwise, you're losing out on time that you could have been in the U.S. with the approved H-1B, because obviously the visa starts October 1st no matter what, but you're not going to get that time back on your approval if it comes after October 1st.
This question, Vikram has this question from YouTube. If you do, why does USCIS approve employment authorization, advance parole for only 1 year for some people and 2 years for some people? He's speaking about the adjustment of status, EADs, and advance parole. Vikram, I have no clue how they are going to determine which ones they're going to approve for 1 year, which ones they're going to approve for 2 years. No clue. I mean, this is like, they just do it randomly, and there is nothing that we can do to tell them, hey, look, you should approve for 2 years. There's nothing there. It's up to their discretion what they're doing on it at this point of time.
Karthik has a question about the H-4 EAD lawsuit and how to get involved in that. If you visit us at rnlawgroup.com or send an email to info@rnlawgroup.com, we can send you more information about what the requirements are to qualify to be included in it, what the cost is, and then you can, if you want to, set up a consultation with any of our team members on our litigation team to learn more about it. Prashant from Facebook also wants to know, kind of along the lines of our approved I-140 that we've been talking about, if you're using an old employer's I-140 to move to company B, how many companies can you keep moving to again and again? And there's no limit. You can move from B to C to D to E as much as you want until your priority date is current. You can keep using that approved I-140 with any company.
I got questions from Spurti from YouTube. What's the update on the second set of litigation on the H-4 EAD? This is, I think, so she's speaking about July 5th litigation that we have filed. We have received a good number of cases getting approved. We haven't received all the approvals at this point of time. I would say we're at about 40 to 50% at this point of time. The cases that we filed on July 5th litigation I'm speaking about. But we have another set of litigation that we filed on July 19th. Yeah, we started getting approvals for them too, but not a significant amount of them. They're trickling in right now. The cases that we filed in July 9th, they're trickling in right now. The approvals are coming in. This is for the H-4 EADs we're speaking about.
Ida from Facebook wants to know if an H-4 extension needs biometrics, and the answer is yes. So any I-539, which is going to be an H-4 extension, an L-2 extension, F-1, change of status to F-1, a B-1, B-2 extension, anything that's filed on the I-539 requires biometrics now. Even if you just did biometrics at the consulate, it's a different agency. They're not sharing those. It's all supposedly for national security, part of some executive order at some point. It's just a big hassle more than anything, and meant to just make it harder for legal immigrants that are here.
Emily, you need to answer this question. I'm a little bit saddened to answer this question. 4-year-old guy, does he need I-539 biometrics?
Yes. Everybody, even infants, everybody.
What can he do? I mean, what can you have committed though?
Yeah, exactly. Supposedly, again, this is supposed to be for national security. They want to make sure.
4-year-old kid?
I know. Well, they want to make sure that the person who got the visa at the consulate is the same person who applied for the renewal in the U.S. because your fingerprints are there and here should match. Supposedly that is the reason, but I think we all know the real reason is just to cause as much hassle and stress as possible for people.
Manohar is the most ideal candidate that I have that is asking this question. My I-140 has been approved for more than 6 months now. I have 4 years left on H-1B. Can I move back to India, reclaim and move back in the future? Assuming that, you said your I-140 is approved for more than 6 months, Manohar, you can go back to India. After 10 years, you can come back on a H-1B without subject to cap, and you can reclaim your I-140 priority date when the new employer is going to file an I-140. I mean, you can come back at any time on H-1B. If you're an employer, you can reclaim the I-140 at any point of time. You're good, you're very ideal. That's a good way to do it. Got your I-140 approval out of the way, and you can keep that for life right now.
Magna from Facebook wants to know what the current time frame is for USCIS to respond after an RFE response has been submitted, and generally it's about 60 days from the time USCIS receives the response to the RFE. Of course, if it's premium processing, they have to respond within 15 calendar days. We do see some RFEs taking longer than the 60 days. So if once it gets to 90 days, then the employer or their attorney can follow up with USCIS by doing a service request for outside normal processing time.
Srinivas has this question: what is a better way of getting the green card for a master's degree guy? Is it EB3 or EB2? Srinivas, it's a tough question sometimes. I would personally, I'm not going to tell you what to do, I would personally like to get the EB2 approval. And here is the reason though. Once you get EB2 to convert into EB3, you don't have to file one more labor certification if the employer is cooperative. But if you were to file the green card under EB3 and you want to convert into EB2, in most of the cases, you have to file one more labor certification. It takes a lot of time. There are a lot of times where I have had cases where the person is not current in EB2 but current in EB3. I have converted EB2 into EB3 without filing the labor certification and filed the adjustment of status along with the I-140. That's the reason why I think EB2 is better than EB3 under your circumstances. But then it depends on the employer cooperation. If the employer says, I'm not going to file an EB3, I already filed under EB2 for you, then you'll be doomed if EB3 becomes current EB2. And this interaction between EB2 and EB3, I mean, it's going to be tough how the things will go on because we can't tell which one is going to go which way. 1 month it's this way, the other month it's the other way. You may want, it's very hard to judge at this point of time.
Aman from Facebook wants to know if an F1 student can start the green card process. It depends. So generally the F1 status must maintain non-immigrant intent, meaning that you don't intend to be working towards your green card. However, depending on how long your wait time is for you to actually file your 485, if you are not subject to the backlog, it may be possible for you to get your perm approved, file your I-140, and file your 485 before your OPT time ever runs out and go straight from F1 to a green card. You'll be limited in travel during that time, and again, it also depends on whether you're from a backlogged country. If you're not, then it might be doable.
Anantu has this question from YouTube. Can you apply for EB1 and EB2 at the same time? Yes, if you have both positions open at the same time, or both positions may be qualified for EB1 and EB2, you can. It may be defensive sometimes to have an EB2 filed, because EB1 is a very tough qualification. Sometimes you may get it denied. If you get EB1 denied, then you may lose the opportunity of extending the non-immigrant visas in some of the times. So sometimes when I see that there is EB1 and EB2, I normally recommend people to file both the things, try both the things, because if the EB1 doesn't work out, you have the EB2 security in there.
Naveen from Facebook wants to know if you filed an H-1B and H-4 and EAD and get everything approved, and then shortly thereafter needs to transfer to a different company, is it necessary to file the H-4 and the EAD again with the new company? No, it's not. The H-4 and the EAD, although they were filed with your particular H-1B petition, they're not tied to a particular employer. They're tied to you, the H-1B holder. So as long as you're maintaining your H-1B status, regardless of which company it's with, the H-4 and the EAD remain valid. So some people do go ahead and file it anyways so that they can get a longer validity period on the H-4 and EAD, and so everyone has the same end date, but it's not mandatory for you to do that.
Deepika has this question, Emily, which I want your attention on, that the USCIS has visited the old client location and issued a notice of intent to revoke. Though they have filed an amendment, they overlooked it. Can they fight it back?
Yeah, I mean, if the amendment was timely filed and the site visit officer went to the,
I take back, Emily, 1 second. Deepika said actually that the amendment has not been filed, but she's working in the same MSA and with a similar job.
So yeah, I think that as long as the terms and conditions of employment are the same, and the only difference is a location change, where that location change is within the same MSA, no amendment is required, and you just need to respond back to the NOIR and explain all of that the original petition remains valid with respect to that new location because it's within the same MSA, and all other aspects of employment are the same. I think you should be able to.
Yeah, Deepika, I would also cite the matter of Simeo Solutions, Deepika, in my notice of intent to revoke response, that look, according to the matter of Simeo Solutions, which was given by decision by the Administrative Appeals Unit, that you don't need to file the amendment. You show them the decision that they have given and tell them, look, according to this, you don't have to file. You don't have to file the amendment, and then you should be fine with that.
Pardeep from Facebook has a question. Can a degree be used for immigration purposes if the university is no longer in existence? If at the time you graduated, the program was accredited, then the degree is still valid for immigration purposes, even if the university later closes down.
Yeah, we have seen some universities, Silicon Valley University is one of the university, which at one point of time was accredited and later on it lost accreditation, and some of the universities were, but if it's accredited on the day you graduated, you are good. One question that pops up is Nebraska Service Center. Did we get any approvals for the second lawsuit from Nebraska Service Center? Yes, we did. We did get the approvals from Nebraska Service Center. Any more questions?
I think it's about time to wrap it up for today.
Thank you very much for coming in. I'm sorry we couldn't get to all the questions as much as we would like to get into. For those people who want to, please subscribe to immigrationgirlblog.com. Don't forget that we do have a daily conference calls. You have to go to RN Law Group to find the details of those things. And if anybody's interested in the H-4 EAD litigation, you can drop an email at info@rnlawgroup.com. Thank you very much, Emily. Thank you. Anything else?
Thanks for joining us.
Thank you.